If the court pleases, my name is Miller Webb and I appear on behalf of the Victorian community. The defendant, Sheena McLaughlin, is charged with intentionally causing injury after slapping her partner, and in this admission the prosecution proposes that the defendant should be sentenced to a community correction order with a conviction for 12 months, during which she attends family therapy and anger management course and undergoes a separate alcohol treatment. Section 18 of the Crimes Act declares that a person who, without lawful excuse, intentionally causes injury to another person is guilty of an indictable offence, and states that the maximum penalty for this crime is a level 5 imprisonment, which is 10 years. While the defence may contend that as a remorseful first-time offender, this case should be dismissed in an attempt to protect Ms McLaughlin's established career as a high-profile barrister, this is a damaging argument to the broader community. The defendant is inarguably guilty. She was unprovoked and aggressed her partner, and if the court does not record a conviction because the defendant's high-profile career is deemed too important to damage, this is likely to reflect poorly on our justice system and entrench the detrimental criticism that the judicial system is elitist and contradictory. Furthermore, a conviction is unlikely to seriously damage the defendant's career, especially if she can demonstrate she has rehabilitated, which can be anticipated given the mitigating factors. Not only did the defendant plead guilty at the earliest possible time, which indicates remorse, but she has no previous convictions, is devoted to volunteer work, and this is the first instance of violence in their relationship. And these circumstances suggest that immediate intervention to encourage rehabilitation will likely prevent such violence from reoccurring and will best support the defendant as well as her family. Consequently, in an attempt to ensure totality and proportionality, it is advised that the defendant should simultaneously receive a CCO and undergo a separate alcohol treatment. Relatively, this is a parsimonious sentence, as according to the sentencing snapshot from 2016 to 2023, 74% of those found guilty of this offence received an immediate custodial sentence. However, CCOs are the second most common punishment, constituting 17.3% of sentences, and of these, 56% were enforced for 12 to 18 months, and so this sentence would ensure parity. Moreover, alcohol-related acts of violence, such as this one, have increased rapidly since the COVID-19 epidemic and has become a national emergency. Consequently, it is the court's civic duty to acknowledge this crisis and to act accordingly to protect our community. The court must denounce all incidents of alcohol-induced violence, and in the effort to reinforce general deterrence. Notably, the defendant often consumes 1 bottle of wine per night, which equates to 8 standards, more than double the 3 daily standards which quantifies a female problem drinker. And for this reason, it is advisable that the defendant addresses her dependence on alcohol via an alcohol treatment. This prioritisation of rehabilitation over punishment is more effective given the defendant's remorsefulness and likelihood to rehabilitate. Additionally, it is essential that the court addresses the effects of the incident on Ms McLaughlin's family. Although the victim has recovered physically, the psychological trauma of the event continues to manifest as she repeatedly ruminates about the evening. Likewise, witnessing domestic violence is particularly corrosive to children. Therefore, this submission proposes that family therapy would be beneficial by simultaneously facilitating a mediated environment in which the couple could reconcile their relationship, and also by professionally supporting Mariella and Liana throughout the emotional aftermath of the incident. Finally, although the defendant is enrolled in an anger management course, she has not attended any sessions, which indicates she is prioritising work over affirmation. And it is imperative that Ms McLaughlin fully commits to the course, and indeed any consequent reduction of her workload may in fact be beneficial. Ultimately, 21.4% of people aged between 35 to 44 who are convicted of intentionally causing injury are sentenced by the Magistrates' Court to a CCO. Therefore, given Ms McLaughlin's age of 42, the proposed sentence of a community correction order in conjunction with alcohol therapy treatment ensures not only parity and proportionality, but also pursues the defendant's rehabilitation and supports her family throughout their trauma.